Okay, going section by section out of the Code of Federal Regulations, CFPB Chapter Truth in Lending Act 1026.10. I'm in payments under Subpart B, which is open-end credit. And A, the general rule under 1026.10 is that a creditor shall credit a payment to the consumer's account as of the date of receipt, except when a delay in crediting does not result in a finance or other charge, or except as provided in paragraph B of this section. B, specific requirements for payments, general rule. A creditor may specify reasonable requirements for payments that enable most consumers to make conforming payments. That's the general rule under specific requirements for payments. Number 2, examples of reasonable requirements for payments. Reasonable requirements for making payment may include Roman numeral 1 through 5. 1, requiring that payments be accompanied by the account number or payment stub. 2, setting reasonable cutoff times for payments to be received by mail, by electronic means, by telephone, and in person, except as provided in paragraph B3 of this section, provided that such cutoff times shall be no earlier than 5 p.m. on the payment due date that at this location specified by the creditor for the receipt of such payments. Roman numeral 3, specifying that only checks or money orders should be sent by mail. Roman numeral 4, specifying that payment is to be made in U.S. dollars, or Roman numeral 5, specifying one particular address for receiving payments, such as a post office box. 3, in-person payments on credit card accounts. General. Roman numeral 1. Notwithstanding 1026.10b, payments on a credit card account number account under an open-end, non-home secured consumer credit plan in person at a branch or office of a card issuer, that is a financial institution, prior to the close of business of that branch or office, shall be considered received on the date on which the consumer makes the payment. A card issuer that is a financial institution shall not impose a cutoff time earlier than the close of business for any such payments made in person at any branch or office of the card issuer at which such payments are accepted. Notwithstanding 1026.10b2 Roman numeral 2, a card issuer may impose a cutoff time earlier than 5 p.m. for such payments if the close of business of the branch or office is earlier than 5 p.m. Roman numeral 2, financial institution. For purposes of B3 of this section, financial institution shall mean a bank, savings association, or credit union. 4, non-conforming payments, Roman numeral 1. Except as provided in paragraph B4(2) of this section, if a creditor specifies on or with the periodic statement requirements for the consumer to follow in making payments as permitted under this 1026.10, but accepts a payment that does not conform to the requirements, the creditor shall credit the payment within 5 days of receipt. Roman numeral 2, payment methods prompted by creditor. If a creditor imposes a method for making payments, such payments shall be considered conforming payments in accordance with this paragraph B and shall be credited to the consumer's account as of the date of receipt, except when a delay in crediting does not result in a finance or other charge. C, adjustment of account. If a creditor fails to credit a payment as required by paragraphs A or B of this section in time to avoid the imposition of finance or other charges, the creditor shall adjust the consumer's account so that the charges imposed are credited to the consumer's account during the next billable cycle. D, crediting of payments when creditor does not receive or accept payments on the due date. 1, general. Except as provided in paragraph D2 of this section, if a creditor does not receive or accept payments by mail on the due date for for payments, the creditor may generally not treat a payment received the next business day as late for any purpose. For purposes of this paragraph, D, the next business day means the next day on which a creditor accepts or receives payments by mail. 2, under Section D, crediting of payments when creditor does not receive or accept payments on due date. 2, payments accepted or received other than by mail. If a creditor accepts or receives payments made on the due date by a method other than mail, such as electronic or telephone payments, the creditor is not required to treat a payment made by that method on the next business day as timely, even if it does not accept mailed payments on the due date. E, limitations on fees related to method of payment. For credit card accounts under an open-end, non-home secured consumer credit plan, a creditor may not impose a separate fee to allow consumers to make a payment by any method, such as mail, electronic, or telephone payments, unless such payment method involves an expedited service by a customer service representative of the creditor. For purposes of paragraph E of this section, the term creditor includes a third party that collects, receives, or processes payments on behalf of the creditor. F, changes by card issuer. If a card issuer makes a material change in the address for receiving payments or procedures for handling payments, and such change causes a material delay in the crediting of a payment to the consumer's account during the 60-day period following the date on which such change took place, the card issuer may not impose any late fee or fine charge for a late payment on the credit card account during the 60-day period following the date on which the change took effect. All right, can I read 1026.11, termination of credit balances and account termination? Let's see. Roman numeral A, credit balances. Roman numeral B, account termination. C, timely settlement of estate debts. Yeah, I can get that part through in this recording. Credit balances. A, subpart A. When a credit balance in excess of $1 is created on a credit account, although transmittal of funds to the creditor in excess of the total balance due on an account through rebates of unearned finance charges or insured premiums or through amounts otherwise owed to or held for the benefit of the consumer, a creditor shall do 1, 2, or 3. 1. Credit the amount of the credit balance to the consumer's account. 2. Refund any part of the remaining credit balance within 7 business days from receipt of a written request from the consumer. Or 3. Make a good faith effort to refund the consumer by cash, check, or money order, or credit to a deposit account of the consumer any part of the credit balance remaining in the account for more than 6 months. No further action is required if the consumer's current location is not known to the creditor and cannot be traced to the consumer's last known address or telephone number. Letter B, account termination. Number 1, a creditor shall not terminate an account prior to its expiration date solely because the consumer does not incur a finance charge. 2, nothing in paragraph B1 of this section prohibits a creditor from terminating an account that is inactive for 3 or more consecutive months. An account is inactive for purposes of this paragraph if no credit has been extended, such as by purchase, cash advance, or balance transfer, and if the account has no outstanding balance. C, timely settlement of estate debts. 1, general rule, Roman numeral I, reasonable policies and procedures required. For credit card accounts under an open-end non-home secured credit plan, consumer credit plan, card issuers must adopt reasonable written policies and procedures designed to ensure that an administrator of an estate of a deceased account holder can determine the amount of and pay any balance on the account of in a timely manner. Application to joint accounts, Roman numeral 2. Paragraph C of this section does not apply to the account of a deceased consumer if a joint account holder remains on the account. 2, timely statement of balance, Roman numeral 1, requirement. Upon request by the administrator of the estate, a card issuer must provide the administrator with the amount of the balance on a deceased consumer's account in a timely manner. Safe harbor. For purposes of paragraph C2 of this section, providing the amount of the balance on the account within 30 days of receiving the request is deemed to be timely. 3, limitations after receipt of request from administrator, Roman numeral 1. Limitation on fees and increases in APR. After receiving a request from the administrator of an estate for the amount of the balance on the deceased consumer's account, a card issuer must not impose any fees on the account, such as a late fee, annual fee, or over-the-limit fee, or increase any annual percentage rate except as provided under 1026-55B2. Limitation on trailing or residual interest. A card issuer must waive or rebate any additional fine charged due to a periodic interest rate if payment in full of the balance disclosed pursuant to paragraph C2 of this section is received within 30 days after disclosure. Can I read 1026.12, special credit card provisions? Or I might have enough time for that. A, issuance of credit cards. Regardless of the purpose for which a credit card is to be used, including business, commercial, agricultural use, no credit card shall be issued to any person except 1. In response to an oral or written request for application for the card, or 2. As a renewal of or substitute for an accepted credit card. B. Liability of cardholder for unauthorized use. Definition of unauthorized use. For purposes of a section, the term unauthorized use means the use of a credit card by a person other than a cardholder who does not have actual, implied, or apparent authority for such use and from which the cardholder receives no benefit. Roman numeral 2 under B, liability of cardholder for unauthorized use. 2. Limitation on amount. The liability of a cardholder for unauthorized use of a credit card shall not exceed the lesser of $50 or the amount of money, property, labor, or services obtained by the unauthorized use before the notification to the card issuer under paragraph B3 of this section. Conditions of liability. A cardholder shall be liable for unauthorized use of a credit card only if Roman numeral 1, the credit card is an accepted credit card. Roman numeral 2, the card issuer has provided adequate notice of the cardholder's maximum potential liability and of means by which the card issuer may be notified of loss or theft of the card. The notice shall state that the cardholder's liability shall not exceed $50 or any lesser amount, and that the cardholder may give oral or written notification and shall describe a means of notification, for example, a telephone number, an address, or both, and the card issuer has provided a means to identify the cardholder on the account or the unauthorized user of the card. 3. Notification to card issuer. Notification to card issuer is given when steps have been taken as may be reasonably required in the ordinary course of business to provide the card issuer with the pertinent information about the loss, theft, or possible unauthorized use of a credit card, regardless of whether any particular officer, employee, or agent of the card issuer does in fact receive the information. Notification may be given at the option of the person giving it, in person, by telephone, or in writing. Notification in writing is considered given at the time of receipt or whether or not received at the expiration of the time ordinarily required for transmission, whichever is earlier. 4. Effective other applicable law or agreement. If state law or an agreement between the cardholder and the card issuer imposes lesser liability than that provided in this paragraph, the lesser liability shall govern. 5. Business use of credit cards. If 10 or more credit cards are issued by one card issuer for use by the employees of an organization, this section does not prohibit the card issuer and the organization from agreeing to liability for unauthorized use without regard to this section. However, liability for unauthorized use may be imposed on an employee of the organization by either the card issuer or the organization only in accordance with this section. C. Right of cardholder to assert claims or defenses against card issuer. 1. General rule. When a person who honors a credit card fails to resolve satisfactorily a dispute as to the property or services purchased with the credit card in a consumer credit transaction, the cardholder may assert the card against the card issuer all claims. The cardholder may assert against the card issuer all claims other than tort claims and defenses arising out of the transaction and relating to the failure to resolve the dispute. The cardholder may withhold payment up to the amount of credit outstanding for the property or services that gave rise to the dispute and any finance or other charges imposed on that amount. 2. Adverse credit reports prohibited. If, in accordance with paragraph C1 of this section, the cardholder withholds payment and the amount of credit outstanding for the disputed transaction, the card issuer shall not report that amount as delinquent until the dispute is settled or judgment is rendered. 3. Limitations. Roman numeral 1. General. The rights stated in paragraph C1 and C2 of this section apply only if A or B. The cardholder has made a good faith attempt to resolve the dispute with the person honoring the credit card, and B, the amount of credit extended to obtain the property or services that result in the assertion of the claim or defense by the cardholder exceeds $50, and the disputed transaction occurred in the same state as the cardholder's current designated address, or, if not within the same state, within 100 miles from the address. 2. Exclusions. Exclusion. The limitations stated in paragraph C3, IB of this section shall not apply when the person honoring the credit card A through F. A is the same person as the card issuer. B is controlled by the card issuer directly or indirectly. C is under the direct or indirect control of a third person that also directly or indirectly controls the card issuer. D controls the card issuer directly or indirectly. E is a franchise dealer of the card issuer's product or services, or F has obtained the order for the disputed transaction through a mail solicitation made or participated in by the card issuer. D. Offsets by card issuer prohibited. 1. A card issuer may not take any action either before or after termination of credit card privileges to offset a cardholder's indebtedness arising from a consumer credit transaction under the relevant credit card plan against funds of the credit card holder held on deposit with the card issuer. 2. This paragraph does not alter or affect the right of a card issuer acting under state or federal law to do any of the following with regard to funds of a cardholder held on deposit with the card issuer if the same procedure is constitutionally available to creditors generally. Obtain or enforce a consensual security interest in the funds, attach or otherwise levy upon the funds, or obtain or enforce a court order relating to the funds. 3. This paragraph does not prohibit a plan, if authorized in writing by the cardholder, under which the card issuer may periodically deduct all or part of the cardholder's credit card debt from a deposit account held with the card issuer, subject to the limitations of 1026.13d1. E. Prompt notification of returns and crediting of refunds. When a creditor other than the card issuer accepts the return of property or forgives a debt for services that is to be reflected as a credit to the consumer's credit card account, the creditor shall, within 7 business days from accepting the return or forgiving the debt, transmit a credit statement to the card issuer through the card issuer's normal channels for credit statements. 2. The card issuer shall, within 3 business days from receipt of a credit statement, credit the consumer's account with the amount of the refund. 3. If a creditor other than a card issuer routinely gives cash refunds to consumers paying in cash, a creditor shall also give creditor cash refunds to consumers using credit cards unless it discloses at the time the transaction is consummated that creditor cash refunds for returns are not given. This section does not require refunds for returns, nor does it prohibit refunds in kind. F is discounts, tie-in arrangements. No card issuer may, by contract or otherwise, do one or two. 1. Prohibit any person who honors a credit card from offering a discount to a consumer to induce the consumer to pay by cash, check, or similar means rather than by use of a credit card or its underlying account for the purchase of property or services. Or 2. Require any person who honors the card issuer's credit card to open or maintain an account, obtain any other service not essential to the operation of the credit card plan from the card issuer or any other person as a condition of participating in a credit card plan. If maintenance of an account for clearing purposes is determined to be essential to the operation of the credit card plan, may be required only if no service charges and minimum balance requirements are imposed. G. Relation to Electronic Fund Transfers Act and Reg E. For guidance on whether Reg Z or Reg E applies in instances involving both credit and EFT aspects, refer to Reg E. Regarding issuance of liability for unauthorized use. On matters other than issuance and liability, this section applies to the credit aspects of combined credit EFT transactions as applicable.